I just want to say that the Department of State Lands issues two types of permits and authorizations: removal fill permits for removal or fill activity in waterways and wetlands, and proprietary authorizations. That's what that word is all about, proprietary. It's for use of state-owned uplands and waterways. Removal fill activity on state-owned waterways requires both permits and authorizations, and Jordan Cove is no exception. The state has removal fill jurisdiction, and the Land Board has directed that DSL is responsible for issuing or denying removal fill permits. The Land Board does not have any specific statutory authority over the removal fill program. So that lies all with me and my staff. And Jordan Cove Energy Project has requested proprietary authorizations for a variety of project components, including easements, upland crossings, leasing, mitigation sites, sand and gravel, etc., etc. The Land Board has delegated authority to DSL to make decisions, including term and permanent easements. It has delegated authority to DSL to issue authorizations. And it has delegated Land Board authority for conservation easements and licenses. The only situation that the Land Board needs to intervene is the Land Board has required DSL to explicitly refer permanent conservation easements to the Land Board. And I will say that as of this time, there are none of those being requested in the Jordan Cove Energy Project application. Now, Oregon Administrative Rule also gives leeway for the director, discretion to the director, to refer unusual or controversial easement applications to the board, as well as a couple of other instances. But I will tell you, this director has no intention of doing that. This director believes that our agency, our department, our staff, is quite capable of making the decisions, and you have given me the authority to make those decisions. So, in conclusion, the Jordan Cove Energy Project has applied for various permits and authorizations that are within the jurisdiction of this department, either under the state's removal fill jurisdiction or the state's proprietary jurisdiction. For each permit and authorization that is contemplated by Jordan Cove's most recent application, the existing statutes and rules place the obligation squarely on the department and the director for deciding whether to approve or deny the application. The Land Board's role is very limited, and considering the scope of this application, as I said, I'm not inclined to refer anything to the Land Board that I don't need to. And we have nothing to discuss at this moment because they have asked us to suspend that application. When they refile, we will have a 60-day public comment period. I already told Jordan Cove Energy Project that I'm going to go outside the 30 days, and I said this is an offer you can't refuse, and they agreed that we can do the 60-day comment period because statute requires only 30 days. We will go, we had already made plans to go to Coos Bay, Canyonville, and Klamath Falls. We had already arranged all of those locations, but we canceled those when Jordan Cove asked us to suspend the application. We will also require the applicant to put their application materials in all the public libraries in the affected counties, and there's quite a few of them. But that way, the public has an opportunity to review the materials. They're also available on our website.
I'm thinking about the scenarios of what happens if there is a leak along the pipeline that creates pollution in a stream or a river. Thinking about a ship that docks and maybe results in a spill. Thinking about what happens after a tsunami and whether it's the Land Board or someone else who would need to cover those costs. So and what that looks like, if it ends up being something like Superfund that ends up in not only the cleanup cost, but the litigation costs and the effort and so on. So
I appreciate the extension on the 30-day public comment period. Given the extensive time frame that the folks managing the project have had, I think it's appropriate that we provide ample opportunity for the public to weigh in. And so I would certainly ask for a longer period of time for public comment consideration. I don't know the regulatory framework around that or the statutory framework around that, so of course Department of Justice would have to weigh in on that, but I'd certainly ask for your consideration. The other thing is, my understanding is the pipeline impacts 4 counties, and given the challenges for folks to travel, I would certainly request that the department make the consideration of having a hearing or meeting in every single one of the counties. I know that my staff has had meetings with a number of the tribes recently. I believe there are at least 4 tribes directly impacted: Coquille, Coos, Cow Creek, and Klamath, and I would certainly ask the department to ensure that there is ample opportunity for the tribes to participate and weigh in.
Governor, we are very aware of that. I have already met with the Coos Law and Quasays Law early on, and I'll be meeting with each of the other tribes, but we'll also make, this is another reason why we're doing Klamath Falls, so the Klamath tribe can attend. Coos Bay, there's 2 tribes there, and then Canyonville. We were actually citing the hearing at the casino.
Okay, great, thank you. Secretary Richardson, any comments? Okay. All right.
My name is Carolyn Partridge, and I very much appreciate the chance to be able to speak, even if only for 1 minute. And I'm here to tell you about my concerns regarding the Jordan Cove Energy Project. I read the climate reports that are coming out from NASA, from NOAA, from the Intergovernmental Panel on Climate Change, from the Union of Concerned Scientists, and even from the U.S. military. They are filled with doom and gloom. I wonder how this affects the psyche of our children. I wonder if their world will be half as beautiful as the one that was bequeathed to me. In my opinion, the South Oregon coast is one of the most precious spots in the state. My family goes there because of the excellent birding opportunities. We enjoy eating the fresh oysters from the bay and hiking along the inland streams and rivers. The scale of this project, the huge scale of this project, will destroy bird habitat and disrupt migration patterns. The birds aren't going to like this. So there will be fewer birds, and it will become an unsightly and hazardous place to watch them. We will skip it altogether. People go out in nature so they can get away from the doom and gloom in the world. They do not go to see pipelines.
Thanks, Carol. Lee? Chambers, Michael Sherman, and Joe Chambers, you are up. Molly Holt, Becky Lifton, and Carol.
Good morning. I'm Ron Wallace, Eugene, with the Sierra Club, and I'm here to talk about the fact that we all know that fossil fuel is on its way out. Renewables are the only chance we've got for the future. This project will make it very bad for the fossil fuel to continue. I'd like you to think about our legacy here in Oregon. We want to be known for perpetuating the negativity of fossil fuels, or we want to be seen for future generations as making decisions now that will make it possible for the next generations to live on this earth. Thank you.
Thank you, Ron.
Secretary Richardson and Treasurer Read for staying to listen to testimony, and unless the director has anything else, we're going to adjourn the land board meeting.
I have nothing.
Okay,
Governor.
thank you. We're adjourned.